Hi, my name is David Ruben with the Ruben Law Firm. A lot of times people call the office and they ask, how old does a child need to be in order to determine which parent they are going to live with, or how often they are going to visit with one parent or the other in a contested custody visitation case. And all states are different with this. For example, Florida has a rule, I believe, that says if the child is 14 years or older, he or she can say where they want to live, and that's what it's going to be. Some states don't take into consideration the preference of the child at all. In Maryland, and that's what I can speak to because we're in Maryland and I practice in Maryland only, preference of the child is one of the factors that the court can consider in determining custody. And when they look to preference of the child, there's no certain age. In Maryland, if a 10-year-old child comes to court and is as mature as a 16-year-old, then the court can perhaps listen to that 10-year-old. If a 17-year-old child comes to court and is not mature at all and has no good reasons or anything like that, the court does not have to listen to that 17-year-old. Usually, and I'll tell clients this, once the child gets up to about 13, 14, 15, the court's going to take seriously what the child has to say. When the child's 16, the court's going to take it very seriously, and rarely is a court going to go against the wishes of a 16-year-old. 17, it's not even going to be a question at that point, because by the time you get to court, the child's going to be 18. The other question about kids and people ask is the judge going to want to talk to my child? Am I going to have to put my child on the witness stand? And in Maryland, we have something called in-camera review. What will happen is your attorney, or you, if you're not being represented, will say to the judge at the beginning of the trial, hey, I would like you to talk to my child. And usually what we're going to do is ask for the child to be talked to in chambers. Now, in one way, that's not fair to the other party because they don't have the right to cross-examine that child. On the other hand, it's a child and nobody wants to cross-examine a child. Nobody really wants to call a child as a witness. Nobody really even wants to bring a child involved in these cases. But while many lawyers will say, no, never involve a child in this situation, I will never say that because every single case is different, and sometimes it is important enough to have a child have his or her say, depending on the facts and circumstances. But what the judge will do mostly is say, I'm going to take this child back in chambers in a comfortable environment, take off my robe, talk to the child as a human being, get some information. Usually they won't even ask specifically what their preference is. They'll just ask roundabout questions and try to get a real good idea of what's going on. And then the judge will come back and say, I'm not going to tell you exactly what we talked about, but generally speaking, this is what we did, and then the judge will consider it. So again, very important question, does my child have a say? And the answer is yes, but the facts and circumstances of each case are different. If you have any questions about custody or anything family law related, feel free to give us a call or an email anytime. Thank you.